and Director of Vital Records, Donna Moore. Before we get started, all phones are on mute. If you have any questions, please type them into GoToTraining using the chat function located at the bottom right of your screen. Please click on the drop-down arrow next to All, Entire Audience, and select Organizer Only. And we're going to address all of those questions at the end. Also, we will be recording today's webinar and provide a link on our website. So at this time, I will turn the webinar over to Director Donna Moore.
Good morning, everyone, and thank you, Gwen, for that introduction. Let's get started. So the purpose and the objectives of today's webinar is first and foremost to inform, educate, and answer questions from our local county registrars relative to the changes in death reporting and registration. I know that there are some funeral homes sitting with our local county registrars who will also benefit from some of these questions and answers. And I also understand that we have some hospitals on the line. Please know that this is directed to our local county registrars, but all are welcome. I wanted to let you know also that these changes we've been talking about for the last 18 months. And many of you, all of you, have heard me in previous registrar meetings talk about the need for electronic registration of our death records. We vetted these changes with our external stakeholder groups, including our funeral homes, our coroners and medical examiners, the Georgia Hospital Association, the Georgia Funeral Directors Association, as well as our own internal groups, including you and DPH staff here at the state office. So why did we make these changes? 3 simple reasons. One, we wanted to simplify the regulations and make them more comprehensive in regards to reporting of death. We wanted to clear away obsolete language and update our language to be more current with modern reality. And then 3, we wanted to make sure that you are able and that we are able, as all Vital Records employees, to be able to provide faster and more efficient electronic means for reporting death information. We all serve the public, and it is our job to make sure that our families of these decedents have what they need when they need it. These changes affected 7 regulations, and you see them here on the slide, and they were effective 14/2017. So let's go through each of these changes one by one, and I'm going to explain the change, and then I'm going to explain what it means and talk a little bit about the practicality of the change for you and your local office. Our first change was to section 19. Can everyone see this slide? Chat me and tell me if you can. Chris, can you come? Hold on just a second. I can't see my own slide here. Hold on. All the better. Thank you, Chris. So in section 19, I want to go over the specific changes with you. In section 2, we updated the manner of reporting. Thank you, Robin. I see your yes. Thank you. So the change was that death reports, including the certification of cause of death, shall be filed electronically with the Office of Vital Records. So that is a change that says that we will now, going forward, require certification of the cause of death electronically. Let's all remember who certifies the cause of death. It's either a physician or a coroner or medical examiner. So this helps us in our strategy of making death reporting fully electronic. In section 5, it says that the electronic death report shall be supplemented by an electronic report of the cause of death. Further edification of using the electronic system of Gavers to report deaths. And then in section 6, the changes were to section A. We now say that the report of death shall be made within 3 calendar days after death. We all know that the report of death comes from our funeral homes. We also say in section 6B that certification of the cause of death shall be made within 3 calendar days, unless it's a coroner case. And what's important here, and I've answered this question for many of you that have called me over the last couple of weeks, is are those 3 days concurrent or sequential? So let's look at that again. The report of death within 3 calendar days, and the certification of the cause of death within 3 calendar days. The intent with electronic registration is for those 3 days to be concurrent, not sequential. It's the same 3 days, unless it's a county coroner or medical examiner case. So we're not going to get there overnight, registrars. It's going to take us a while to meet this requirement. But if we don't set our goal, if we don't set our finish line, we'll never get there. And that's the intent of this regulation, is to set the expectation out there that this is where we're going and that this is our goal, this is what we're striving for. And then in 6C of section 19, it says if for any reason the cause of death cannot be determined within 48 hours, then under review shall be entered on the death report and amended later. And if the cause of death, until the cause of death is certified, final disposition shall not be made unless authorized by the attending physician, or with regard to a coroner case, it has to be approved by the county coroner or medical examiner. So let's talk about this for just a minute. The records management team, Joe Little and Gwen Duffin, have been working diligently with our coroners and our medical examiners and have gotten agreement from that group to use pending or under review so that we are able to issue, so that you as local county registrars are able to issue pending cause of death records to your families, to your decedent families. That's really, really important when you have a family that needs to access their loved ones' financial records, utility bills, affairs. Now, most insurance companies won't take a pending cause of death as a requirement for issuing insurance, but for all the other things in our daily lives that those families need a death certificate for, this allows them to get it quickly. So our deal with the coroners and the medical examiners is that when they submit a supplemental cause of death form to the state office, we will turn that around in 24 to 48 hours. Gwen has made that commitment, Joe has made that commitment, I have made that commitment. And we have a dedicated resource at the state office to make that happen. And the feedback that we've gotten from the coroners and the medical examiners says that we're honoring our commitment. So that's section 19. That's the language in section 19. I want to make a point here, and as we go through the presentation, many people have said to me, rules and regulations aren't the law. And I think it's important that we as registrars, both here at the state office and locally as well, Title 31 is our legislation, it is our law. Our rules and our regulations are administrative law. It is administrative law. It's not an option for us to not follow our rules and regulations. as local registrars and as the state office. So what are the three major changes? Just to summarize for Section 19, reporting and cause of death within 3 calendar days after the death event. We're moving to electronic reporting and GAVRs rather than drop to paper or fax. And then coroners and medical examiners will use pending or under review, and we will amend the cause of death once it's determined. In a lot of these coroner cases, when they do toxicology, it could be 8, 12 weeks before results are back and cause of death is known. We don't want families to have to wait that long for a death certificate. So that's Section 19. Let's move on to Section 20. Section 20, pure and simple, was repealed. And that was the language that needed to be assumed into 19 was. So 20 has gone away. 20 has been repealed. And then Section 21 talks about disposition of reports of induced termination of pregnancy. And here at the state office, we call those ITOPs. And this language was simply updated and simplified to say that induced terminations of pregnancy are collected solely for epidemiologic reasons, and that the state registrar can retain those as long as he or she deems necessary, and then they shall be destroyed. So State Office of Vital Records reports into the Department of Public Health, and we have epidemiologists on staff that use this data to understand trends in our marketplace, trends in our communities in Georgia, and they use it strictly for research. Section 23, let's talk a minute about permits for disposition, disinterment, and reinterment. So in Section 1, a very simple change that says one word, jointly. So an application for disinterment and reinterment must be signed jointly by the surviving spouse or the next of kin, the owner of the cemetery, and the cemetery plot, and the person who is in charge of the disinterment. So those three signatures need to show up jointly on that application. In Section 3, we added some language that gives the local county registrar a little more flexibility in meeting the 24/7 requirement for disposition permits. And the language that was added says, for this purpose, the local registrar, meaning you all, may appoint local persons or entities, including hospitals, hospices, and funeral homes, to serve as deputy local registrars for the limited purpose of issuing a disposition permit. So again, that gives you more options as the local registrar for who can sign and who can issue disposition permits. Now, we all know that there's at least one or two of you out there who have given your local funeral homes pre-signed disposition permits for their use, and that's how you've addressed the 24/7. But that puts you at risk, that puts the decedent and the decedent's family at risk, that puts the funeral home at risk, and even in some instances, the coroner may not be too happy with you. So I'm going to share with you in a few minutes what we can do so that you can honor that obligation of 24/7. And then in Section 4 of 23, it says, a disposition permit shall not be issued until the cause of death has been certified by the physician under Section 19, or authorization is given by the decedent's attending physician, or the coroner has given you approval for disposition. So let's talk just a minute about what a disposition permit does and what it doesn't do. A disposition permit allows for the cremation transportation, or donation of a body. You do not need a disposition permit for a burial, but you do need it in those three situations: cremation, donation, or transportation across state lines. Why is that important? Because when one of those three things happens, there's no going back. So the meaning behind the disposition permit is that you have as a local county registrar satisfied your own mind that you know whether or not the decedent died from natural causes or not. And if it's the or not, then you want to make sure that the coroner has done what he needs to do relative to that body in order to complete his case. So let's talk again about what are the three major changes. We talked about jointly for disinter and reinter. We said a disposition permit cannot be issued for those three situations until cause of death is known or the attending physician or coroner gives you approval, and that we've expanded options for the 24/7 requirements that the local registrar make disposition permits available all the time. So one of the questions I've gotten over the last couple of weeks is, can a disposition permit be issued even though a death certificate has not? And the answer is yes. If the attending physician tells you that it was a natural cause of death, if the coroner says it was not my case, or it was my case and I've done what I need to do, you can now cremate, donate, or transport. Or if the physician has already certified the cause of death in the system. So you have three situations when you can go ahead and issue a disposition permit before the death certificate is available. So let's talk just a few minutes about how to expand my options for the 24/7 requirement. So I want you to consider, local county registrars, who works 24/7 and who has the information and the knowledge to make decisions on your behalf. So what I would recommend is read section 22, which I've copied here for you, and add it to section 23. So what does section 22 say? Section 22 did not change. Section 22 says that before removing a body from its place of death, the person removing the body, 99% of the time it will be your funeral home or your coroner or medical examiner, that person that removes the body obtains assurance from the attending physician or physician, associate physician, or chief medical officer of the institution in which the death occurred, be it a hospice or a hospital, that the death is from natural causes and that the physician will assume responsibility for certifying the death. Section B of that paragraph says, or notify the coroner or medical examiner if the cause of death falls within their jurisdiction, or if the physician cannot certify the cause of death, get assurance from the coroner or ME that he or she will assume responsibility for certifying the cause of death. So what does this really say in section 22? This says that when the funeral home or the coroner or whomever picks up the body has gotten assurance from either the doctor that it was a natural death or from the coroner that they will assume responsibility for cause of death. And why is that important? Because those individuals are collecting that information already. And in section 23, I just shared with you that you can appoint those folks to serve as deputy registrars in your county for the limited purpose of issuing disposition permits. So this is an opportunity for you as the local county registrar. You can choose to appoint local deputy registrars or not. It is up to you. The key here is that we have to tighten, as registrars, we have to tighten our compliance with disposition permits, and we have to satisfy our own minds that we know the cause of death, either natural or not, or that we get assurances from the coroners. Many of you are calling your coroners now and saying, is this an active case of yours? If they tell you yes, then ask the question, have you done what you needed to do? Can I go ahead and issue the disposition permit? Or if they tell you no, the follow-up question from you is, was it a natural death? So if you want to retain responsibility for issuing disposition permits out of your office, you absolutely can. It is at your discretion. But this is one suggestion for you as local county registrars. You can appoint local deputy registrars to do this for you. And again, you need to consider who works 24/7 and has the information and knowledge to make those decisions on your behalf. I would recommend that you consider funeral homes and coroners to play this role for you. Why? Because the funeral home is already picking up that information when they pick up the body. So I would also recommend that you consider a licensed funeral director to sign these disposition permits on your behalf as a local deputy registrar. I would suggest and highly recommend that you appoint one person in the funeral home to play this role for you. But this gives you more options, and it leverages your relationships with it leverages the relationships you already have with these funeral homes. And you're both working to the same end, which is doing right by our families and doing right by the decedent. No one wants to issue a disposition permit and have a body cremated if it's a coroner case. No one wants to do that. No one wants to make it hard on families to get what they need to dispose of body. I talked to a couple of funeral homes yesterday who told me that their cremations are 40 to 50% of their business. So cremations need to happen relatively quickly, but we need to do it with prudence and diligence. Local registrars, whether it's yourself or someone that you have appointed to play this role with you, need to have confidence that you are signing that disposition permit for either a natural death or that you've gotten clearance from the coroner. Again, I recommend that you seriously consider your funeral homes and your coroners to play this role for you, unless you already have a situation where you're able to issue disposition permits 24/7. Again, consider licensed funeral directors. The other thing that I'll tell you is that the state office has been working on a revision of the disposition permit, and we will be able to use that form. You will be able to use that form as an attestation for any local county registrar, any local deputy registrar that you appoint. They will have to attest that they have this knowledge and this information before they issue a disposition permit under their signature. So there are 9 situations when a coroner has to get involved in a death. And I don't know if our local registrars know this. I'm assuming that many of you and most of you do, but I just wanted to review them quickly. In Title 45, there are 9 situations where a coroner has to be involved and notified of a death. The first one is violence. Second is suicide. Number 3 is suddenly. 4 is when a person is unattended by a physician, and that excludes someone who died in hospice. Number 5 is if it's a suspicious death. Particular attention to those that are 16 years of age or younger. Number 6 is between the ages of birth and 7 years of age, if the death is unexplained or unexpected. Number 7 is in an execution. Number 8 is to an inmate. Number 9 is having been admitted to a hospital either unconscious or without regaining consciousness within 24 hours of admission. That's when a coroner has to be notified and involved in a death. So moving on to section 25, the amendment here is to all other amendments, and the change was to simply to add the certifying physician as someone who can amend a death certificate. Previously, the certifying physician was not included in the language. Section 26, who may apply to amend a vital record. We struck the language or person acting as such. And in section 38, transmittal of certificates and reports. This is simply to align local registrars with the agreement that you have with the State Office of Vital Records to transmit that report electronically same day or next day. So it was simply bringing this regulation in compliance with our MOA. The previous language had it listed at 10 days. If you want a copy of the updated regulations, you can find them at dph.georgia.gov/directors-governance. Local county registrars, you've been trained on how to find this information on our website, so please go out there and read the regulations for yourself. I think it would be important that you know the official language that's in our administrative law. It is 10:30. I think Gwen is coming up. We're going to open up to questions.
Okay, thank you, Donna. So at this time, we're going to open for questions, and I can already see that we've received quite a bit of questions, and we want to respond to as many as possible. So let's go ahead and get started. Okay, this first question. Can I issue a disposition permit before the death certificate is available? You want to take that one, Donna?
Yes. So as I mentioned previously, you can issue a disposition permit before the death certificate is ready. But in order to do so, you need 3 things: a certified cause of death from the physician, or authorization from the decedent's attending physician that it was a natural death, or approval from the coroner that the decedent is not an active case if they died under suspicious circumstances, or that the coroner has already done what they needed to do with the body.
Okay, here's our next question. Let's see. It says it's 5 p.m. on a Friday afternoon. Disposition permits are to be available to funeral directors on a 24/7 basis. What can we do to accommodate the families we serve regarding the new regulation on weekends and holidays versus the way we've obtained permits for the last 20 years?
Oh, that's a great question. So in the past, the system of issuing or accommodating 24/7 was to pre-sign disposition permits. But again, that puts a lot of people at risk for lack of diligence, lack of compliance, lack of vetting the information that you need to confirm that it was a natural death or a coroner case. So the criteria still has to be met, but once the criteria is met, you still have an opportunity to provide a permit via fax, via email, via pickup. And as I mentioned earlier, if you want to accommodate the 24/7, we've added that language in the regulations that gives you an additional option to appoint a deputy registrar specifically for the issuance of disposition permits. And I shared with you my example of the funeral homes or the coroners. You can choose to do this. You may choose not to do this. Many of you have relationships with your coroners. I talked to one of our local registrars the other day, and she said her coroner is her brother. Many of your funeral homes have relationships with your coroners. So this is purely at your discretion, but I think it leverages the relationships you already have with your funeral homes as you partner with them to take care of families.
Okay, thank you, Donna. That was a really good question. And here's another really good one. Several other counties that I know of are continuing to issue permits the old way. If I'm doing it the right way, my funeral homes are getting mad at me. And I guess the question is, what should I do?
So I am hopeful and I am confident that you now know what your options are, and that the explanations in today's webinar will clear up any inconsistencies that may exist across our local registrar group. I will tell you too that this webinar line has space for 200 call-ins, and we have 159 registrars, and I'm not sure that all of us were able to dial in today, but we will make this webinar, as Gwen mentioned at the beginning. Gwen, won't we
We will make it available on our website.
Okay. So again, I'm hopeful and confident that today's webinar will clear up any misinformation that may be out there and get us all on the same page and governing the same way.
Okay, thanks, Donna. Okay, next question. We have a funeral home that has a body that is due to be cremated as soon as we're able to obtain a disposition permit number. The person died on Friday. Vital statistic information from the family on Saturday. The funeral home entered the record into Gathers and forwarded for electronic certification to the doctor on Sunday. Today is Monday. The funeral home needs to cremate ASAP. We are waiting now for the coroner to approve the cremation. What else would you recommend we do?
That's a great question. That's a very practical question.
That's a good one.
So here's my answer. I think you're doing the right things in contacting the physician or the coroner. A disposition permit cannot be issued by you as the local registrar until you are satisfied that you have met the 3 criteria: certifying the cause of death, or approval from the attending physician and confirmation that it was natural causes, or that the coroner gives you approval. And the coroner can say, it's not my case, or I've done what I need to do with the body, you can cremate now. You do not have to have the death certificate finalized in order to issue the disposition permit. Also, approval can come either verbal or written. So you can pick up the phone and call your brother Bob, who's the coroner, and say, hey, what's the deal with this decedent? Or you can ask for an email or a fax. Many of you may not feel comfortable with verbal confirmations. You may want written confirmation, and that's fine. If you do accept verbal confirmation, then I would encourage you to document the conversation, date it and time it, and who you talk to. Now remember that the purpose of the change in the regulation is to ensure that we're not cremating, donating, or transporting until the local registrar is confident that the decedent is not part of an active case. And as I mentioned, you can appoint local deputy registrars to help you in issuing disposition permits. Gwen, I saw one I want to answer.
Okay.
I saw one that came across that said, my funeral homes are telling me that it's my job to get the certified cause of death from the physician or to call the coroner in order to issue the disposition permit. They're telling me that that's my job, not their job. Whose job is it? That's a great question, and I have an answer for you. But I want you to understand that this issue is a shade of gray. It's not a black and white issue. In some counties, registrars, you have a great relationship with your coroner, and you have them on speed dial. In other counties, you have a great relationship with your coroner and have them on speed dial. Some counties, the funeral homes know the coroners on a first name basis. This is not an either or answer. The answer is both. You need to work together to get what you need to support the families. And I think this alignment of taking care of families is what binds you together. It's not an either or, folks. It's an and. And it's not one size fits all for every county. It's what do you need to do in your county? Who are your partners? Who can you support? Who can support you to help make this happen?
Okay, thank you, Donna. We've got one more. Can I get verbal approval from the physician or coroner to issue a disposition permit for a cremation? And that question has come up quite a bit.
Yes, and you can get verbal approval. And again, if you accept verbal approval, because you can get it written or verbal, if you do take a verbal confirmation from a physician or a coroner, keep a note of who you talked to, the date and the time, and keep that in your own records. The other thing I want to say to you is, even if you appoint a local deputy registrar to issue disposition permits, local registrars, you're still responsible for keeping copies of those and getting copies of those from your deputies. So if you decide to go that route, make sure that you're still getting copies of those disposition permits, those attestations from your funeral homes or coroners for your files, because you are required by law to keep those indefinitely. Some of you may choose to go that route. Some of you may not. Some of you may already have a system in place where you're able to accommodate the 24/7 requirement and everything's working just fine. Others, this gives you more options and allows you to help the family and your partners locally in your counties.
Okay, thank you, Donna. So we're getting quite a few questions about the forms, and you mentioned the form in your presentation today, and they want to know when are we going to be changing that form and making it available? Are we changing the forms to show that this requirement? And I think you've already touched upon that, where you said that we are in the process of working on disposition permits, and we will be providing another webinar in the first quarter where we will talk specifically to the forms and the new process in terms of the disposition permits.
Yes, and I encourage you to keep using the permit forms that you have now, other than the ones that you may already have. I've heard that some local registrars are recalling pre-signed disposition permits. And that's okay, because you're trying to do the right thing. But what we want to give you, in addition to the forms that you have now, we are updating the forms so they can be used by you as the local registrar, or an attestation from whoever you appoint as a local deputy registrar for that limited purpose. And I think we can get that out, if not the end of this week, the beginning of next week. I just got a head nod from our Deputy Director of Program Administration that we'll make that available either by the end of the week or early next week.
Okay, so let's take a couple more. So this question is, since most of our physicians that we deal with are not on gathers, and therefore we have to wait for the death certificate, our experience has been sometimes a week to get the death certificate back. So how do we get around this?
Okay, so I appreciate this question more than you know. The state office spent most of 2016 asking doctors to register into Gavers. And we made some traction, probably not as much as all of us wanted. And so through this regulation, we now have set the expectation for electronic reporting and electronic certification of the records. You've heard me say before, local county registrars, in our trainings and in our webinars and in our meetings, that we know who the 1,600 physicians are that certify 80% of the deaths. Now, it's important that you understand there are 35,000 physicians in the state of Georgia that can certify a death record. We can't go after 35,000. But we can go after the 1,600 who do the vast majority of the certifications, and that is what we're doing now. We have already started with the top 300, and our state office team here has started issuing user IDs, passwords, and PINs to physicians, not asking them to join, but telling them that this is their login, their password, and their PIN based on the new administrative law. Now, this won't happen overnight, folks. It's going to take a while to get them in. But we are committed to making sure that we do the heavy lifting here at the state office to get those physicians signed in and signed up to Gavers. And I want to tell you, if we can get these 1,600, then we've got 80% of the deaths. The other thing that we've asked of you in the past, and we'll ask again, is if you have a particular doc that you want in the system, notify your regional consultant or Joe Little or even me. Tell me who they are. We'll get them signed up. The key is we've got to change their behavior. And so we are working with our external partners, including the Composite Medical Board, the Georgia Hospital Association, to make sure they understand the why behind it. We're not trying to browbeat physicians to do this. We want them to understand the importance of doing this for their client, who is the decedent, and the decedent's family. And we need all of us. We need the local county registrar to continue to spread the word. We need the funerals to continue to spread the word. The state office is spreading the word, and now we're going to get other stakeholders involved as well. That was a good question.
That was a good question. We've got one more here. My coroner here, and I won't say the county, will not sign a pending death certificate. What do I need to do? I think you kind of answered that in the last question, and that is where you need to follow up with Joe Little, who is our training manager and a regional consultant for your area. They will do the heavy lifting for you on that part. So if you got a coroner who will not sign a pending death certificate, let your regional consultants know, and we'll do the follow-up on that for you, okay? So let's see. So now this question. So you are saying that if we get a verbal cause of death from the physician or coroner, a permit can be issued without having the death certificate issued?
Yes, that's what I said.
Okay. So the next question, can a hospice statement of death be used for a permit request?
So that's a good question too. And I've seen the pronouncement of death form, and I've seen some of the forms that hospice sends out. So remember what our criteria is. You've got to have a certified cause of death or authorization from the physician or approval from the coroner. So I would ask you, does that pronouncement of death form or anything that you get from hospice, does that meet your criteria? Because the intent of the regulation change is to give you more options, but we've got to get away from having lack of compliance with answering those 3 questions. We've got to get away from having disposition permits that are pre-signed and doesn't give us the vetting and the confidence that we aren't doing right by the decedents.
Okay, thank you, Donna. Our next question, will Georgia ever remove the disposition date from the death certificate? The state of South Carolina does not require this date. So they want us to remove the disposition date from the death certificate.
That's an interesting thought. I know that South Carolina turns around death certificates in about 2 days. Louisiana does it in 2 days. I think Arkansas does it in 2 days. Florida does it, I think, in 4 days. Here's the real answer to your question. We'll take a look at it, but the key is most of those states implemented their death module, their death registration module, their system before their birth module. We did it in reverse. We implemented birth before we implemented death. Is that right, Chris? No. So those states are farther advanced than we are in their death registration process. We have really been studying this issue for, like I said, the last 12, 18 months. Mm-hmm. But we'll take that under advisement and see whether that'll work for us in Georgia or not.
Okay, so the questions keep pouring in. Okay, may we still share death records between counties as you stated in your email of July 13th, 2015? The answer to the question is yes. But let me expand on that and tell you that at some point you won't need to. Our digitization project is well underway, and that we have already this year scanned and digitized and indexed 4 million records. So at some point, you're going to have that information at your fingertips. But yes, because death records typically do not change. I would ask you to be diligent, though. If you get a death record that says pending or under review, you know that there's probably more to the story. But yes, you can continue to share death records. Okay, so this next question is regarding pending and under review. So for pending or under review on death certificates as cause of death, most insurance companies require the cause of death.
So I think I answered this one, but I'll answer it again. If you have a death certificate that is pending or under review, you can issue it. You can issue a certified copy of that death record. Here's what you need to know. That allows families to take care of their decedent's affairs, but most insurance companies will not accept that for insurance requests, insurance benefit requests. But it still allows you to take care of the utility bill and the mortgage, and accessing, the family can access the decedent's accounts at the bank. We have another question here that just came through, and I want to answer this one, Gwen. Okay. It says, some hospitals' documents state that the coroner has been contacted and released the body. Is that approval for disposition permit? I would say yes. I would say yes. I would say that would be approval. If the coroner has been contacted and said, this is not an active case of mine, or I've done what I need to do, I've collected the samples I need to collect, and the family wants to cremate the body, then I would, as a local county registrar, I would use that as confirmation and documentation that it's valid that the coroner has been contacted. You know, again, I want to say to all of you out there, this is the art part, not the science part of your job. I trust you, the state office trusts you, you trust each other to do right by these families in issuing disposition permits. You partner with the funeral homes. 99% of the time when a funeral home picks up a body, when a coroner picks up a body, they know the cause of death. They know if Mrs. Jones had a fall. They know if Mrs. Jones died of cancer. They know. So you're going to know too. It's just in those situations where you have to be diligent in that gray area of the unknown. And this gets us to a place where we can get confirmations from a variety of folks. What else we got, Gwen?
Okay, yeah, the questions keep coming in. When appointing a deputy registrar for the licensed funeral directors, is this per funeral home or just one or two per county?
So that's a great question. So it's at your discretion. It's at your discretion. What would I do? I would appoint one licensed funeral director per funeral home. If I had a good relationship with them, if I know that they are the ones who have the information and the knowledge. I don't think I would put a funeral home at the mercy of another funeral home and having them get permits from each other. That doesn't serve your purpose. But I think that you've got the relationships with these funeral homes and you know what you want to do. Some of you, as I mentioned earlier, already have 24/7 processes in place and you're just fine. You don't want to change the system. Others of you don't want to be called on a Saturday or a Sunday because we've got to meet that 24/7 commitment. We also have to meet the commitment of knowing that we're not cremating, donating, or transporting until we are confident that it's a natural death or the coroner has given us clearance to do so.
Okay, that was a good question. We do many fetal deaths where no death certificate is issued, but we need disposition permit for the cremation. How will that be handled?
I don't think it's any different. I think a fetal death is a death and it has to be handled the same way. All right, I'm going to scroll back a few slides. Yeah, in section 1 of 23, where it says an authorization, I'm sorry. This refers to both death and fetal death. It captures all death. So a fetal death disposition permit, I think on the disposition permit you check fetal death or you check death. It's the same expectation. Yeah, here it is. Existing section 22, before removing a dead body or a fetus, meaning a fetal death, we still have to meet this criteria.
Okay. So our next question, will funeral homes be aware of these changes as well?
Oh, great question. So again, I know that many of you, some of you have funeral homes sitting with you during the webinar right now. The other thing that I want to tell you, and I'm glad that question came up, is I have prepared for you as local county registrars, the state office has prepared for you an email or a letter that you can send to your funeral homes, either via regular mail or email, to explain these changes to them. And that is, again, at your discretion. If you want to send it out, you can, but we'll make that available to you. You can cut and paste, you can use all of it, you can use some of it, but send it out to your local funeral homes under your signature, not under mine, but under your signature, because again, what you do locally You've got the relationships there, and the funeral homes will learn of it that way. The other thing that Gwen mentioned is that we have taped this webinar, and the funeral homes will have access to the website as well. And they can watch this webinar after the fact. And then we continue to have a great relationship with the Georgia Funeral Directors Association, its officers, its community of funeral homes, and we are meeting with them next week and going over these changes with them as well. I will tell you, though, that they have already posted on their websites the regulation changes. They have already carried the water for us in alerting their funeral homes to the changes in the rules and regulations or administrative law, and we are grateful to them for that.
Okay, let's take a couple more, Donna. We've got here this question. Can hospitals such as Choa Egleston release the body of an infant or child and permit to a family member that is not a licensed funeral director or staff representing funeral home or medical examiner or coroner?
Can a hospital release a body of an infant or child and permit to a family member that is not a licensed funeral director or staff representing funeral home or ME? Joe, you want to answer that one?
Yes. I've received this question a couple of times. You cannot release a body to the family because they cannot transport a body within their vehicle. So you have to be an officiant to actually transport the body. So if you give them that disposition or you release that body to them, they are actually breaking the law by transporting that body across. So you have to give it to an officiant in order for them to be able, because I've had people call and ask, can they take their relative in the trunk or in the car or wherever, and we really have a problem with that. So I would say no to that question. The funeral home has those, and then there's some transport companies.
So the question from the audience here at the state office was, does a family that wants to take their infant need a specific license? And Joe said there are transport companies out there.
Because they're not allowed to transport the body themselves in your own vehicle. You have to have a funeral director.
You have to have a transport license. Some of the transport people are not funeral directors.
Okay.
What's the next question, Gwen?
Okay, a lot of questions about bringing our doctors on board. Will all doctors be required to file cause of death electronic and not drop to paper? Most of my doctors are not on the system. I think you've already addressed that one, but we've got that question in several different, asked different ways.
So we're at 11 o'clock, so I'm going to be quick here because we're about to drop off our call. We want doctors who certify deaths in the system. And we want doctors to certify deaths electronically within 3 days. We're not going to get there overnight, folks. We will get there. But the state office's focus right now is getting those first 1,600.
Okay, so we've had a number of really, really great questions, and we want to be respectful of everybody's time. So if we didn't get to your question, we want you to follow up with your regional consultant, and we will be happy to answer any additional questions. We want to thank Director Moore for a great presentation today. We are recording this webinar. We'll send a link of the recording to the attendees and also make it available on our website. We probably won't send the link because I think sometimes when we try to send it, it's too, you're not able to open it, but we will make it available on our website, so you'll get an email response from us. We are expanding on our webinars, and we welcome your feedback on content for future webinars. Once again, thank you for attending our webinar. Have a great day.